You are now rocking with BizMode. Let's get into BizMode. What is BizMode? BizMode is entrepreneurship at its highest level. BizMode is flow state. BizMode is that hunger pain you feel. BizMode is success by your own definition. BizMode is operating from abundance. BizMode is what you make it. This is BizMode. What up, though? I am your host, Alex Bruno. I am the founder of Bruno Group Inc., a California law firm helping entrepreneurs and businesses with their legal stuff. Family, how are you? If you're listening to this podcast and this episode close to when it published, I know the past few weeks have been emotionally draining for you. I send you my love, and my wish for you is that you find a way to create space for yourself so you can recharge. I'm coming to you today with a solo episode on a topic that I hold near and dear to my heart. I'm a product of the golden era. If you know what I mean, reach out to me at Twitter at Alex Bruno ESQ to let me know about that golden era. I may have a BizMode prize pack for you. Actually, for the first person to explain the golden era to me. Anyway, when I was in college, I heard the Wu-Tang Clan's song, CREAM. CREAM is an acronym for Cash Rules Everything Around Me. Well, I'm a business lawyer. For me, contracts rule everything around me. If things keep going at the rate they are, it may change to crowdfunding rules everything around me. But that's for another episode. Wink, wink. If you're an entrepreneur, a business owner, a founder, contracts likely rule everything around you too. No matter what level your business and company is at, you will always have to deal with contracts. If you're just starting, you need contracts for your team. You need contracts for your co-founders. You definitely need contracts for your customers and your clients. You need contracts for what you are selling. If you're building your online presence or maybe an app, you will need terms of service or terms and conditions. That too is a legal agreement, a contract. If you fundraise or sell your company, you'll need a contract for that too. I think you get the point. So today's topic, I want to focus on some important sections that most contracts should have. Again, this is purely informational and it is not legal advice. If you're preparing a contract, you should consult an attorney in your area. Now, let's get to that topic. In my opinion, there are certain sections every contract should have. First, let's start with, in my eyes, something easy. How is the contract going to end? Most contracts will have language on when a contract would end. There may be some writing identifying the date the contract ends. However, a contract can end not just on the passage of time. We can make a contract end when services are provided or when goods or product is delivered. We can terminate a contract if the other party breaches another section of that contract and doesn't fix it. We can terminate a contract if the other party had to do something before you had to fulfill your end of the bargain. For example, if the contract requires a down payment before you start any work, your contract may state that you will not perform your side of the deal until you get down payment. And if you don't get down payment within 10 days of signing the contract, well, you can terminate the contract. With termination clauses, you want to think about all the ways a contract can end and have language, protective language for those ways. So on to another area. Your contract should also address if you can transfer the entire contract or any portion of it to someone else. For example, if you have a client, a really good client, locked in a contract for 5 years, does your contract say that you can transfer the contract to someone else? Having such language would be helpful if someone wanted to buy your company. If the buyer can take over that contract with no problem, that would be an attractive and added value to your business. It would be an asset that you own. Now, when the contract might be too personal for, let's say, certain types of services or like talent, being able to transfer so easily may not be the best thing. And there should be language preventing that. So, what you're looking for in this section is something we call assignment. Can you assign or transfer the contract over? Or can you not? Or can you maybe with consent, what we call you have to ask the other party and say, hey, I'm about to get acquired by a company that does great work. They'll be a great service provider to you. Will you consent for them to take over the contract? So that could be a portion of it too. But you also want to check to see if you have a successor to yourself or the party that you're contracting with has a successor. Are they going to be bound by the terms of the contract? You want to make sure they do that. So let's say that you have a client and that client merges into another company, and that client, now that it merged into a new company, no longer exists. Well, you want to have language in your contract that's going to say the new company, is responsible for your client's obligations. Now, there's another provision that really enjoyed a resurgence last year during the height of the coronavirus pandemic. That is the force majeure clause. Now, force majeure, roughly translated from French, means superior strength or superior force. I like to call it the act of God paragraph. In contracts, if something were so crazy were to happen, you can be excused from a contract and not be legally liable to the other party. Certain examples include extreme weather events, say a flood like Hurricane Katrina that happened some years ago, or a super earthquake that's going to break down a lot of California where I live, maybe an act of war, a strong labor dispute, or like what we're going through, an epidemic, a pandemic. The key component here is that the act is something that's going to be beyond your control or beyond the control of the other party that you're contracting with. So you have no way to change things. Like with the pandemic, when the businesses were shut down, you had no way to change that. Especially for our restaurants and our other retail out there. Another key to this is that it is important to identify what would make up a force majeure event. Before COVID-19, many people ignored this clause. Now, I'm seeing a lot of contracts where people are mindful of this clause. From my viewpoint, you should be very specific as to what would be a force majeure. Many companies are still fighting over whether or not COVID-19 applies. Now, you cannot prevent the next event that could shut down life as we know it, but you can generally identify it, which would give you a fighting chance to get out of a contract that you really can't perform. Speaking of fighting, we never want this to happen, but there may be a situation where you have a misunderstanding or a dispute. First thing you want to understand is what law is going to apply. And I don't want you to take this lightly. I do not want you to take it lightly. Does the law of the state where your company is headquartered apply, or is it the law of the other party? You need to have knowledge on this and negotiate for a law you and your team are familiar with. Next, your contract should have language on how something would get resolved if an issue comes up. We usually refer to this area as dispute resolution. Typically, I like to have a starting point of informal, good faith talks to resolve an issue. If those informal talks do not work, maybe try a mediation. A mediation, by the way, is a meeting between the parties and a neutral mediator whose job it is to try to help you come to a solution or a resolution. If a mediation is not successful, you want to have language to move it to arbitration. Why arbitration? Well, I'm based out of California. To take something through the court system here will not only take up resources, but may also take a long time. By history, arbitration is a quicker process and it's not a complete depletion of your resources as a potential court action can be. And for those who do not know, An arbitration is an out-of-court process where an arbitrator, who sometimes, or actually a lot of times, is a retired judge, resolves your issue for you. A couple of notes here. When you are adding language on arbitration, you also have to agree on how you pick an arbitrator. What is the process for picking the arbitrator to make the decisions for you? You also want to make sure that once the arbitrator makes a decision, that decision is going to be binding, binding on you, not bounding. It's going to be binding on you. And you should agree on what the rules you're going to use to conduct the arbitration. Now, keep in mind that we're really talking about arbitration language for commercial contracts, for business contracts. When you're dealing with when you're dealing with employees, there are different rules in different states for how you can draft an arbitration agreement or arbitration provision. So you got to be mindful of that as well. And again, talk to your local lawyer on this stuff. I also like to carve out language in my arbitration paragraph to make certain exceptions. For example, if my client has to go to court for certain things, they should be allowed to do so. Like let's say the fight is over something that can be resolved in small claims court. So they're fighting over, outstanding bill of $5,000. Well, you really don't want to arbitrate that. You should be able to skip arbitration in certain situations like that. Or let's say a party has to get an emergency court order if someone is threatening or improperly using their intellectual property. You don't want to wait for an arbitration process, although it's quicker to play out when you got to get an immediate emergency court order. Sometimes we call that an injunction to stop someone from infringing on your intellectual property or improperly using it. There's a lot more to add, but I just wanted to kind of touch the surface here with certain provisions that you really got to look out for. And if you like this topic, let me know, because I feel like a part 2 may be rolling out in the future. But I will leave you with this. As an entrepreneur, when you are building, you're already on alert for what ifs. The main takeaway that I hope you get from this is to read your contracts and make sure that you are anticipating and planning for the what ifs. Now, there are many good advisors and counselors and lawyers and other people as part of your team that are going to help you plan for those what ifs. So here's to better contracts and super informed founders. Thank you for listening. Talk soon. Until next time, BizMode family, this is your host, Alex Bruno, Bruno Group Inc., BizMode Podcast. Keep your family first. Always strive for perfection. Don't forget, none of this is legal advice. By the way, what happened to peace? Peace.